Hey, everybody. As always, I'm having issues with putting it down. Also, why is it so cloudy weird? Okay, anyway. Hey, party people and Natalie, this one's for you. Here's my CivPro outline. It is made in the order that I went through every single one of her midterms that she posted and final exams, and anything in jurisdiction or pleadings I copied down and refined into a rule statement. So it's mainly going to be rule statements, but I might do some filler. But this is it. So this is the order in which most of them were written, so this is my plan of attack in reading them. Okay. So it starts with Rule 12 motions. So I start with the timing of them, and there is a beautiful chart right here. You can read it. So the timing of them is on Rule H, and it basically says that a B2 through 5, which are the bulk of them, they must be brought together in the initial response or else they are waived. They need to be brought before or in the answer once the court rules the case. Once they rule on the 12 Bs, because they are motions to dismiss, if the court rules granted, then the case is dismissed. But if they are not granted, the defendant has 14 days after the motion is ruled on to then answer the complaint. So that's what Rule H1 says. H3, this again is just timing rules. H3 says that 12B1, which is subject matter jurisdiction, can be brought at any time and may be brought up by the court. So if they find that there's no subject matter, the case will be immediately dismissed. And then according to 12H2A, a 12B6 and 7, so 6 is the complaint does not contain a prima facie case, and 7 is failure to join, which we haven't really talked about yet. They can be brought at almost any time, but they have to be expressly written in their answer and given as possible affirmative defenses. If they are not, then they are waived. But if they are, then they can be brought at any time. So a bunch of the essays started with, is P's motion to remand okay? So the rule statement here is under 1447, if a defendant brings an action of removal, P can fight back by bringing a motion to remand within 30 days if there is a procedural defect. So P files in state court, D removes it to federal court. In order to do that, D has to show that they have subject matter jurisdiction to go to federal court. So if it's a federal question, from the time D knows that it's a federal question, they've got 30 days to take it to try to remove. But if it is a diversity reason, there's 2 hoops. So it's 30 days from the time that the defendant finds out. So if if there were 2 defendants and the plaintiff and the plaintiff and the defendant were from the same state, then no diversity. But say they settle, and so now you only have the same state plaintiff defendant left, then now they're diverse. So at that time, the defendant can remove to federal court, but they only have 30 days once that situation happens, and it has to be within 1 year of when the case was originally started. So that means if 2 years out there's a settlement agreement, then no, they can't remove. The exception is the Caterpillar case, and That was just, if it goes all the way to the end and then there is a final judgment, the plaintiff, even if they appeal and say, well, like, we didn't have diversity, the appellate court, the Supreme Court said, hey, as long as it was fixed by the time the final judgment was given, we're not, for efficiency's sake, we're not going to do anything about it. So that kind of sucks, because for justice sake, that may not be the right answer. Okay, anyway. So the rule here, so removal by the D, remand by the P. The P says, no, we don't have subject matter jurisdiction, and if the court rules you're right, then they remand back to the state. So it says, under Rule 1447, if a defendant brings an action of removal, P can fight back by bringing a motion to remand within 30 days if it's not true. So the remand has to come within 30 days. Under 1441, a defendant can remove to federal court if there is original subject matter jurisdiction and the federal district court embraces the state court. D can remove the entire case under 1441C, but only if the federal court has supplemental jurisdiction over the state claims. So for that, you need to do, and we'll get to that later, but you're going to need to do a supplemental jurisdiction analysis to see if they do have supplemental jurisdiction over any state claims that might go with the whole case. In order to properly remove, P must assert that the court had either original jurisdiction or supplemental jurisdiction over their claims. And one other thing, if the plaintiff files in the defendant's state of domicile, then even if there's diversity, they cannot, in a diversity case, they cannot remove to federal court because they already think that the defendant has a hometown advantage, so they won't allow. But a federal question, the hometown rule doesn't drive. Okay? All right, so now we've got 12B1 motion, and that's subject matter jurisdiction, and it can be brought at any time. A federal court has original subject matter jurisdiction if there's a federal question or if there is diversity. We're going to get deeper into those, but that's the basic rule. Original jurisdiction refers to where a case originates. The timing. A Rule 12H3 allows a 12B1 motion to dismiss for lack of subject matter to be brought up at any time and may be brought up by the court. If any time the case lacks subject matter jurisdiction, the case will immediately be dismissed. So a federal question under 1331, district courts have original jurisdiction over all civil actions arising under the Constitution, its laws, or treaties. A suit arises under the Constitution only when a plaintiff's statement of his cause of action shows it is based on those laws, or what we call a federal question. It cannot be some anticipated defense. So if it's like a suit for libel and the defendant wants to claim First Amendment rights, that's an affirmative defense. So that is a federal question, but that's not the case. The case has to be based on a federal question. The defense doesn't matter. So, and then states have concurrent jurisdiction where both federal and state can take a claim over a federal question. So you can bring a federal question to a state court. That's totally fair. Unless it's expressly barred by exclusive jurisdiction, which is like patent law or bankruptcy law, which is always in the federal court. That is where only one court has authority to hear the claim. And a state also can have exclusive jurisdiction, and that's something like family law. Okay, diversity. Under 1332, the district court has original jurisdiction over all civil actions where the matter of controversy exceeds 75,000 K. It has to exceed, so a penny more is fine, but it's got to exceed. And they have to be completely diverse, meaning the citizenship of all the P's differs from all the D's. All the P's, they could be the same. The multiple D's could be the same, but the P's and the D's have to be completely different. Did I just say that? I'm not sure. P's and D's, completely different. A state court holds concurrent jurisdiction over diversity claims as well. So you could take it to state court too. That's fine. On individuals, it's a strategy game. Okay, so citizenship is defined. An individual's citizenship is the state in which they are domiciled. Being domiciled requires physical presence as well as an intent to remain. Goodno says if her hypo says they are from somewhere and there's no other information, that from is their domicile. A corporation citizenship is where they are incorporated or where their principal place of business is, which is almost always where they are headquartered. Yeah, for the purposes now, we're going to keep that. And then it has to exceed $75,000. This amount prevents flooding in the court. So Rule 11, generally, we trust P's alleged amount because you will get Rule 11 sanctions if maybe you were lying or it's frivolous. P's unrelated claims can be aggregated to reach above 75K. But multiple plaintiffs cannot aggregate because their claims are separate and distinct. Every once in a while, if there is a common undivided interest, so a hypo in Glannon was if Timothy and John have a promissory note from Kathy for $100,000, they own it. They each own a half, so each of theirs would be $50,000. But it's one promissory note, so that would be a common undivided interest that they could sue on. So if they are joint or joined, then it can be a common undivided interest, and then it works. Otherwise, plaintiffs don't get to add their stuff together. So the word you're going to look for is jointly, then they can aggregate. If P is over and one is under, they may be able, so if the plaintiff is over but there's someone else with a claim under, they might be able to get supplemental jurisdiction, but again, you'll need to do that whole analysis separately. Okay, so then we have supplemental jurisdiction. Supplemental jurisdiction is under 1367. It is where a claim that would otherwise have subject matter jurisdiction in federal court can hitch a ride on a claim that does. So in a federal question case, there can be subject matter jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form the same case in controversy under Article 3 of the Constitution. They need to include a common nucleus of operative facts, which we'll talk about in a second, and they must fall within the court's discretion. On diversity cases, we're in 1332 world, and if D joins a party that so they also need to do the common nucleus of facts and court's discretion, but in diversity cases, the defendant can join anyone they want, and if it destroys diversity, it doesn't destroy the case. But the plaintiff, because they think, okay, the plaintiff might be playing a game here by trying to get federal, if the plaintiff joins a party that destroys diversity, then it will destroy, then the court will not allow supplemental jurisdiction. And that also includes if the plaintiff wants to add a defendant that would destroy diversity, the federal court is going to say, no, that destroys your diversity. So plaintiff can't join, even in supplemental, that would destroy diversity. So to find if there's supplemental jurisdiction, you're going to do two IRACs. The first one is going to be, is there a common nucleus of operative facts? And that rule statement is, in cases where there is a claim under original jurisdiction for a federal question, the court has supplemental jurisdiction over all other claims if it shares a common nucleus of operative facts. I'm going to ask Goodno tomorrow about this analysis with diversity claims because it's not clear in here. Which means she doesn't test on that very often because I would have it in here if she did. Because I literally just ripped it out of the rule language. Okay, so let me read that again. Common nucleus of facts. In cases where there is a claim under original jurisdiction for a federal question, the court has supplemental jurisdiction over all other claims if it shares a common nucleus of operative facts, in which the claims tell one story so as to share the same case or controversy. Okay? That's one IRAC. The second one is court's discretion. If the courts were to find that there is the same common nucleus of facts, the court has discretion, 1367C. the court has discretion to reject supplemental jurisdiction if the state claim, 1, raises new and complex issues, 2, substantially predominates the case, or 3, courts has dismissed all the claims with original jurisdiction, or 4, there are exceptional circumstances. And then you hear because, and let us know why that happened or not. And then conclude. Always conclude. All right. Moving on to personal jurisdiction, which is a 12b2 motion. And this is Rule 12b2 motion is a motion to dismiss for lack of personal jurisdiction. Personal jurisdiction determines which state a defendant may be sued in. I remember this because I think PS stands for state, PS, personal state. And it's about the defendant. Which state a defendant may be sued in. It is concerned with the Constitution giving citizens due process of law and giving state courts full faith and credit to do their own thing. Okay, so the first thing you're going to look for, we have a long chart for this. If I can find it really fast, I will show you, but you know this one well. Okay, so this is the chart for this one. Okay, so the first thing you're going to look for is if there is a waiver or consent, because that'll stop your analysis right there. Consent. When a D consents to personal jurisdiction of a state, the state has personal jurisdiction. This could come from a forum selection clause. A forum selection clause in a contract is binding when there is no bad faith motive and its enforcement is fundamentally fair. These types of clauses are typically enforced when, 1, it was included in the contract for a special business with a real interest in limiting its jurisdictional liability, like a cruise ship, and 2, its enforcement increases efficiency and clarity among potential plaintiffs, and 3, its savings translates to customers. This another reason could be waiver if D fails to assert the 12b2 motion in the first appearance, so the first time they respond, the issue is waived and the forum state will have personal jurisdiction. Removal is an exception to that because they can remove before they respond. All right, so if there's no waiver and no consent, moving on, you look for what is the state's long-arm statute. A long-arm statute allows a state to decide what defendants to exercise personal jurisdiction over, as long as it does not violate the Constitution. So California long-arm statute is a full reach statute that allows the exercise of personal jurisdiction on any constitutional basis. That is the only statute that was in her past exams. That was it. So she actually wrote it out, but it was always California and it was always long-arm. So if it isn't California, it might be a specific act statute, and that means a state wants personal jurisdiction only over specific defendants. This is less than the Constitution will allow. So that's a specific act statute. So once you decide if it's long-arm or specific act, you're going to do constitutional due process, and that is what's going to show you the constitutional basis, which is under the long arm, because the long arm is just saying like, hey, you do what you do, you boo, to the federal government. The 5th and 14th Amendment of the Constitution state that due process is required. This means the court must establish they can exercise personal jurisdiction over defendants. They do this by the 2-pronged shoe test. If 1, there was minimum contacts, and 2, there is fairness in bringing a lawsuit in that state. It is unclear if this is an and/or test. If you satisfy one or both of those, you're good to go. And then if you are in federal court, you want to add Rule 4K1A states that federal courts have personal jurisdiction over defendants in any state that the state courts therein would also have personal jurisdiction over. So those are your main rule statements, and then you're going to go to prong 1, which is minimum contacts. Under the shoe test, minimum contacts with the forum state are established based on the nature of the contacts, single and isolated or continuous and systematic, and whether the claim is related or unrelated to the contacts. If they are continuous and systematic and relate, if they are continuous and systematic, and related, such as the place of domicile for an individual or the principal place of business for a corporation, then the state has general jurisdiction over the defendant. In order for minimum contacts to be established when the contact is isolated and related, also known as specific jurisdiction, the defendant must have purposely availed himself to the forum state. So, that's the rule statement that you're going to use. Then you're going to do the analysis. So, traditional basis is easy personal jurisdiction. And that is when a contact is continuous, and that's going to be, it can be a company or a domiciled individual. For a company to have continuous systematic contacts, they must be incorporated in the forum state or have their principal place of business there. Excuse me. I'm coming back. There is one exception, and that was the Perkins case, and that is if the language you're looking for is if the contacts are so substantial that the company is essentially at home in the forum state. But Perkins, was it a Japanese company? They were in Ohio because they couldn't actually be in Asia because of the war. And they said, you're pretty much at home here because you can't have any other options. But that is the only case where they've ever allowed something out of headquartered and incorporated. If it's an individual, it's going to be the state where they are domiciled, and that is their physical presence and intent to remain. So those are easy. If you've got those, it's traditional basis. There is personal jurisdiction. Okay, so then we have related, which is specific jurisdiction, and we have unrelated, which is general jurisdiction. Where a claim is related or unrelated to the forum state, when D's contact is continuous, the state will always have personal jurisdiction over the D. So this is the quadrant map. So let me get it out. Oh my gosh. Did I not print that one? That's ridiculous. Okay. So continuous and related is like up here. We have quadrants. Continuous and related would be in this one. And so you're always going to have minimum contacts with that one. So that's an easy one because it's related to the claim. The person's always there. The state will have jurisdiction. Okay. And then also in their home state, unrelated claims, a home state will always have. So that's your traditional basis one. So physical presence rule. Here's where it gets a little more, you got to do some work. Physical presence rule. An individual who is physically present but not domiciled in the forum state when personally served is automatically considered continuous and systematic contact, such that the court may exercise general jurisdiction over them, meaning that they can be sued for any claim in that state, regardless of whether or not it is related to their contacts with the state. There is a split in which tests to apply: Scalia, his tag rule, or Brennan, the transient rule. So we must do them both for now. There is an exception if the presence was due to fraud or illegality, kidnapping or coercion. So the Scalia tag rule says, according to Scalia, a state may exercise general jurisdiction over travelers given personal service on the basis of the precedent of Pennoyer. This rule is known as the tag rule. Personal service automatically constitutes general jurisdiction. So if you come into the state, tag, personal jurisdiction. But we also must do the Brennan transient rule, and then that one requires the two-prong shoe test as well. Okay, so according to Brennan, physical presence in the state creates substantial contacts that gives rise to general jurisdiction. This is by virtue of their being in the state and thus personally availing themselves to its protections, rights, and amenities. Here, during the duration of D's time in the state, D accessed the roads and infrastructure, and it is assumed that D was trusting the state police force and other government officials to protect D in case of an emergency. Brennan argues that this intense contact with the state constitutes systematic and continuous contacts with a foreign state such that the court may exercise general jurisdiction over D, meaning that he may be sued for any claim, regardless of whether or not this claim is related to his contacts with the state. The fact that the claim of blank is related to D's contact with blank state is immaterial for general jurisdiction, which is kind of them, like Brennan and Scalia saying the same thing. But with the transient rule, you do also need to do the fairness prong of shoe. So Brennan further argues that D's physical presence in a state at time of personal service inherently fulfills the fairness and reasonableness test to international shoe. There are 5, so you need to fairness, which is there are 5 factors to consider, and they are D's burden, which is heavily weighted. D would not have too much of a burden because D shows he was already here. Then you have P's interest. Then on the other side of the scale, you have P's interest. P wants to keep it in this state because, and then you have the state's interest. The state has an interest here because. Judicial interest, the efficiency factor comes into play for the courts because, and they want to keep it here because witnesses, blah, blah, blah. And then what are other states' interests as well? And then here the other states might have an interest because blah, blah, blah. And then that's the whole Brennan rule, transient rule. And then you do the analysis, conclude, done. Okay, then so we've basically, we've done this one always, this one, physical presence always. Now you're down here. So your isolated contacts, unrelated claim, you're not gonna have jurisdiction there. So that rule statement is when contact is single and isolated and the claim is unrelated to the forum state, the state will not have personal jurisdiction over the D. This is the Schaefer quasi in rem category. No deal. All right, now we've got continuous or single and isolated and related to the claim. So here is where 90% of our case is going to fall. There is going to be something on this, okay? So this is the one you need to be able to do. This, she said, can take up like 3 to 5 pages, so get ready. If a court determines, so specific jurisdiction, single and personally availed / related. Here's a rule statement. If a court determines that a D has single and isolated contacts with the forum state, that court may exercise personal jurisdiction over him on the basis of his casual presence, only if he satisfies the 2-pronged shoe test. 1, that he purposely availed himself to the rights, benefits, and privileges of that state by reaching out to conduct activities there, and 2, it would be fair and reasonable for the court to exercise personal jurisdiction over him. So for personal availment, the D has purposely availed himself to the forum state if he has invoked the benefits and protections of its laws. There is purposeful availment when D should reasonably anticipate being hauled into court into the forum state. And then you're going to pick the test that applies to show if the D personally availed himself. So, stream of commerce without the internet. For stream of commerce case that is not on the internet, the rule is to apply O'Connor's stream of commerce plus something more. D must have put a product into the stream of commerce, i.e., bought something and done something more by directing conduct at the forum state, such as specifically targeting advertising in the forum state. So not bought something, but put something into the marketplace. Foreseeability alone is not enough. Purposely availed himself to the forum state. Stream of commerce with the internet. When there is a stream of commerce case that includes the internet, the court is split on how to test. Great. Brennan wants stream of commerce only. Oh, look at that. He's doing something easy. What? O'Connor says stream of commerce plus something more. And you also have Zippo, which looks at the websites. We need to do all 3. The stream of commerce alone test with internet Brennan. Under Brennan, it is sufficient to demonstrate that because D put a product into the stream of commerce, it was foreseeable that the product would end up in the forum state. Foreseeability alone is sufficient under the Brennan test. Great. Then we have O'Connor's stream of commerce plus something more, which we just did. Availing itself to the forum state, D must have put a product into the stream of commerce, i.e. Sold something and done something more by directing conduct to the forum state, specifically targeting advertising at the forum state. Foreseeability alone is not enough. Then we have Zippo internet test. Zippo uses a sliding scale to determine whether D has personally availed himself based on the type of website interactivity. Active, interactive, or passive. When dealing with selling of goods online, it is necessary to determine the nature of the website that they use. The more active the site, the more likely there is a personal availment. So active, interactive, passive. Active, you've got personal availment. Passive, you do not. Interactive could go either way. Then you have the intentional tort, Calder's effects test, and this could be fraud, it could be battery, libel, slander. Per the Calder effects test, personal availment is present when D engages in an intentional tort expressly aimed at the forum state. So this is elements. Intentional tort expressly aimed at the forum state, and he knew it would cause harm in the forum state. And then you have a contract claim. For a breach of contract claim to determine purposeful availment, the court will ask whether the D deliberately reached out to the forum state. This can occur when the contract has substantial connection with the forum state, or if the D specifically solicited business in the forum state. So those are going to be your, here, the defendant deliberately reached out to the forum state, had substantial connection to the forum state, and specifically solicited business to the forum state because he did this, this, and this. It must be more than just unilateral activity from the plaintiff. The court may also consider choice of law provisions and the bargaining power between the contracting parties. And then lastly, we have the Zippo internet test, which we already said, but Zippo could be like an intentional tort over the internet, which would be no stream of commerce, but you would still do Zippo. And once again, Zippo will use a sliding scale to determine whether D has personally availed himself based on the type of website interactivity, active, interactive, passive. When dealing with the selling of goods online, it is necessary to determine the nature of the website that they use. The more, so you probably take that sentence out if no commerce, because you're going to use it in a different fashion, but I did it. I just cut and pasted, sorry. The more active that site is, the more likely that there is purposeful availment. All right, that's the first prong. Find it in any of those tests, and you've got personal availment. Find it in none of those tests, and you're going to have to do fairness anyway, because fairness, the purposeful availment and fairness, we don't know if it's an and test or an or test. So even if you don't find any purposeful availment, you may still have fairness. We don't have, it's getting to the maybe. The second part of the test is whether it would be fair to subject D to personal jurisdiction in the forum state. Fairness weighs the defendant's inconvenience heavily against the four other factors. We already said those, but once again, D's inconvenience, P's interest, the forum state's interest, the judicial interest, several states' interest. All right, ladies and gentlemen, that is personal jurisdiction. That was the page in my paper. So that's like the biggest thing that we're gonna find. So everything else, now we're just headed straight downhill. Okay. 12B3 motion to dismiss based on improper venue. The term venue refers to the geographical specification of the proper court or courts for the litigation of a civil action that is within the subject matter jurisdiction of district courts. So it's the city. Venue is the city. Under USC 1391, federal venue is proper 1, where the defendant resides if all defendants are from the same state, 2, where a substantial part of the events occurred, and if not 1 and 2, then 3, where D is subject to personal jurisdiction. This motion happens when the venue is wrong and it ends the case. If number 1 is satisfied, so where any defendant resides, if all the defendants are from the same state, then it's governed under 1391C. And this tells us the meaning of residency for an individual. It's the place of domicile. For a company, it's where the D's company is subject to personal jurisdiction, so incorporation or headquarters, and for resident aliens, it can be anywhere. If it is the wrong federal court and you want to move it to the right federal court, then you're going to do a motion to move, and that's a 1406A, and that's statutory, and that is the court will move from the wrong federal court to the right federal court in the interest of justice, and this will continue the case. But if it's just an okay federal, but you want to move it to a better federal court, it's a motion 1404, and that is a motion to transfer, and this moves the case from an okay federal court to a better federal court, or to where the parties have consented to. So this is if, like, the P brings a case and it would generally be fine, but then the D is like, motion to transfer because we have a consent clause. We're gonna move. So that's 1404. So it doesn't end the case, it just moves it. It just transfers it, sorry. Removal is by motion, and it moves the case between a state and federal court. So we already talked about that in subject matter jurisdiction. Motion to dismiss for venue 12B3, where we are right now. There's also forum nonconvenes, which we'll talk about next. This kills the case, although usually without prejudice, so it can be refiled. Declining jurisdiction, forum nonconvenes. This is a common law, and this is the plaintiff's presumption. There are times when a court has personal jurisdiction, but for reasons of justice and efficiency may choose not to exercise it. This motion dismisses the claim from the whole U.S. It's usually on claims that arise outside the U.S., and it goes to the state court system. So there is a strong presumption to deny forum nonconvenes, which is FNC, to plaintiffs if the plaintiffs are United States citizens. So plaintiffs who are not citizens, they tend to say, like, this isn't the right forum for you. But when the plaintiff is a U.S. citizen, they want to protect them more. So to do a forum nonconvenes, you're going to weigh public and private factors. The court also weighs, so they do the presumption for the plaintiff. Does the plaintiff have, like, are they U.S. citizens? If they're not, is there an alternate forum? If the alternate forum provides a remedy of some sort, then that cannot be reason to deny. So if it's a Swiss plaintiff and Switzerland just has a stricter law and it's not going to be as great, then they're probably not going to do it. But if it's like Rwanda, and their government is completely shut down, or another third world country like that, and there's no alternative, there's no court system, the U.S. will probably allow it. But aside from that, the court is also going to weigh private and public factors when deciding. The private interests include the location of both witnesses and evidence and the cost of hearing the case in the U.S. That's the Scotland case. Everything was in Scotland. All of the people who died were Scottish. Like, it made no sense. There was, like, a piece of property in California, and then some secretary in a legal firm took, like, what? No. Public interests include considering court congestion with foreign claims, interest in having case decided at home, familiarity with law, and conflict of law between countries. So I didn't see that one in any of the things, but maybe a multiple choice. Okay, 12B4, insufficient process. Oh, this one's so easy. The rule is about being served improper paperwork. It's not about the service, it's about the paperwork. So most often the complaint or summons is not signed, or maybe it doesn't have the stamp of the clerk or something. It's insufficient, but it's just the paperwork. 12B5 though is improper notice, and that's about the service. So D's motion to dismiss for improper notice brings up two rules. Under Mullane, that's the constitutional provisions, notice must be reasonably calculated under the totality of circumstances to give defendants notice. Rule 4 heightens the standard by requiring personal service in federal court unless waived. But under Rule 4E1, P may serve defendants in federal court according to the forum state rules, so long as they do not violate Mullane. And violating Mullane means that under the totality of service, it doesn't give the defendant notice. So as long as it doesn't violate that, you're good. So Mullane. Under federal constitutional law in Mullane, personal service is always adequate Personal service is always adequate, but not required if impractical. The note. Okay, hold on. I need to plug you in. Okay. Sorry about that. Okay. Personal service. The notice must be reasonably calculated given the totality of circumstances. That's Mullane. Rule 4. Rule 4 has a heightened requirement of service than the reasonableness rule of Mullane. Service must be in person unless waived. Under Rule 4E1, a P can follow the requirements for service that are the same as the state courts where they are filing, so long as they satisfy Mullane. Rule 4 requires personal service, no phone, fax, email on individuals in corpse, unless waived, but will allow service that is allowed in state of personal jurisdiction if it satisfies Mullane. So follow the rules of the state. That's part of the rule language. You'll be fine. Other Rule 4 language. Service of process is the procedure in which D is notified of a lawsuit. Rule 4C requires personal service of a complaint. Under Rule 4D, D can agree to waiver of service of process by accepting summons or complaint by mail, so they get a form to fill out. This is the courts give them a stick and a carrot for this. The stick is Rule D2. If D fails to waive, the court must impose cost of service on D. The carrot is D3. If D waives, D gets 60 days instead of 21 to respond to the complaint. Okay? The government and minors / people who are incompetent or for whatever reason can't take care of themselves, they cannot waive service. So they gotta be served under Mullane and Rule 4. Rule 4 only applies to complaints, not motions. And the remedy for service evading. D. Rule 4M, if P fails to serve D within 90 days after filing the complaint with the court, the case is dismissed, but court may extend the time for a bad faith evader, and if you are evading, the court also may impose cost, which they may have already done because you wouldn't waive. All right, 12B6, failing to state a claim. We're so close, guys. To bring an R12B6 motion to dismiss, the D must show that P failed to state a claim upon which relief can be granted. Under Rule 8A2, P must set forth a short and plain statement of the claim. Short and plain means that P must set forth allegations that are non-conclusory and plausible on its face. Under Iqbal, a claim cannot be formulaic recitation of the elements without specific facts and must have more than mere possibility of misconduct supported by factual allegations. Claim means that P must set forth a prima facie case, making allegations that establish elements of the claim. The court is limited to the four corners of the pleading to make a ruling. So in your here because sections, you're going to have to do conclusory. Are the statements conclusory? Are they plausible? And are all the prima facie elements met? So conclusory and plausible can probably be one IRAC, but prima facie is going to be a second. And then if it's a fraud claim, it's under Rule 9. And fraud is a special claim that under Rule 9 must be pled with particularity. It has to state a time, place, and the nature of the allegation. When alleging fraud, the party must state with particularity the circumstances containing the fraud. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. Okay. Statute interpretation. is something an element or an affirmative defense. So this was the case about the prison complaint, and they were saying that did his complaint need to discuss how he had already fulfilled all of his administrative options to get relief before he filed the claim, which was a requirement, or was that an affirmative defense? And the difference is, like, did he need to plead it in the complaint so it was on the plaintiff, or does it need to be pleaded in the answer as an affirmative defense by the defense? So which side needed to do it? In interpreting a statute using the method laid out in Bach, there are 3 steps process for statute interpretation. To determine this, first, the court should look at the plain language of the statute. Second, legislative history. And third, the court will examine the usual and common practices if necessary. This can be used to determine affirmative defenses that must be pled under Rule 8c, or if it needs to be part of the plaintiff's prima facie claim, such as whether the exhaustion of the mediation is an affirmative defense that must be pled by the defendant or part of the prima facie case in the complaint. I think I said that twice. I might need to fix that before the test. The burden of pleading is on the P for the prima facie elements and the D for the affirmative defenses. It's particularly complicated because an affirmative defense not brought up in the answer are affirmatively waived. Rule 12C is a motion to dismiss on the pleadings. Only the 4 corners of the pleadings can be used. If this is violated, then it will turn into an MSJ, which is a Rule 56, and it turns into that under Rule 12D. Usually this would be like statute of limitations. So the complaint says, here are the 4 elements and everything's fine with them. And the answer says, even if that's all true, the statute of limitations is passed and I win. Then you have a Rule 12E motion to dismiss for lack of definitive statement. And this is like, I have no idea what you're saying. Goodno said this is like sometimes prison claims are just like, what? And that's what it is. It's like, I can't even tell you what the prima facie elements you didn't meet are because I have no idea what you're claiming. And then Rule 12F, motion to strike. P is mean, and the motion is to take out the offense from the record. Motion to amend. Rule 15. Amendments enable cases to be heard on their merits while reducing the injustices that sometimes come with stricter pleading requirements. It seeks to balance Rule 1's goal of truth, justice, and efficiency. Given these considerations, timing is everything. A court's willingness to grant an amendment will largely depend on the stage of the suit. The farther into discovery, the less likely a court is to allow an amendment. Under Rule 15a, 1 amendment is allowed within 20 days after serving or a responsive pleading. 15a2, pleading amendments should be allowed if they have either 1, written consent of the opposing party, or 2, court permission, which should be freely given as justice so requires. Courts have interpreted the phrase as justice so requires to mean that there is no evidence of bad faith, delay, or lack of diligence on the part of the plaintiff. It also requires that granting the amendment would not severely prejudice the defendant. Rule 15c, relation back doctrine. Under Rule 15c 1b, the parties can add a claim or a person to a lawsuit. If a statute of limitations is run, an amendment can relate back to the date pleaded for claims if the proposed amendment has its basis in the same transaction, conduct, or occurrence involving the same nucleus of operative facts as the original complaint, and there isn't prejudice, bad faith, or undue delay. So relation back is only going to happen when there is a statute of limitations. Only going to happen if there's a statute of limitations. Okay? Only going to happen. Relation back, statute of limitations. All right, so if it is a relation back new claim, the critical issue in R15C is the determinations is whether the original complaint gave notice to the defendant of the claim now being asserted. So it can't be something completely new. It's got to be like, I don't even know. I'm tired. I'm sorry. But it's got to relate to the original claim. If it's like, we had a car accident and you painted my house funny, not going to happen. But if it's a new person, Also, P may add a new defendant when 1, the first was incorrect, or 2, the new defendant is on notice, 3, and knew or should have known the action would have brought this against them. So like person, insurance company. So the here because portions you're going to need for those are IRAC for the same transaction. Here the proposed amendment has its basis in the same transaction, conduct, or occurrence because. And then delay, here the delay was not from prejudice, bad faith, or undue delay because notice, here the defendant had notice because he should have had notice because I just had an R there. It should be or. All right, guys, we're so close. What the heck? Okay. Rule 11, shame on you. Rule 11 requires lawyers to stop, think, investigate, and research before filing signed papers or documents like motions with the court. Signed with the court. It enforces an objective standard of reasonableness on lawyers, but it is limited to signed papers submitted to the court, such as pleadings, written motions, etc. A lawyer can initiate sanctions by serving the motion to the other side, but the lawyer must then wait 21 days. This is the safe harbor period, during which time the erring attorney can correct the issues. A lot of times this was like they filed the Rule 11, they filled it out, and then they submitted it to the court. No safe harbor period, no good. During which time the erring attorney can correct the issue. If an issue still remains after these 21 days, then the lawyer may file it with the court. So you're going to do here because it was a written document filed with the court, because it was a written document filed with the court. And then you're going to do here because it was reasonable. It was a reasonable reason. So Rule 11A, it wasn't signed. Rule 11B1, the lawsuit improper person was improper purpose, or it was to harass or delay. Rule 11B2, bad law. 3, bad facts. 4, bad denials. And this is all knowingly. Or they should have known. They didn't do their research. And then here because they did the safe harbor time or they didn't do the safe harbor time. If a judge initiates a Rule 11C, it will be an order to show cause, and the offending lawyer will have 3 days to write a letter to the court for why they did this. The court also has inherent authority. While Rule 11 applies to pleadings, the court has inherent authority to provide sanctions for lawyers when they have an explicit finding that the individuals acted in bad faith. A court can pretty much put anything under inherent authority. They cannot put everything under a Rule 11 motion. So if they provide sanctions for behavior under Rule 11, it will be overturned for error because it's got to be inherent authority if it is not a signed document to the court. All right. Rule 8. This is easy, guys. This is just like our everything else. Rule 8A, complaint, has 3 parts. A jurisdictional statement. Rule 8A1, federal court subject matter jurisdiction, either federal question or diversity, and the venue, specific location, city, district within the state. Then it has Rule 8A2, short, plain statement of the claim, factual allegations to establish a legal claim, cause of actions, counts. And otherwise, it must prima facie. It must be plausible, non-conclusory. And then it must, 3, R8.3, demand for relief, or prayer for relief. So that is the complaint. Then then the court, the ball is in D's court. D can, 1, default. If D doesn't answer, or Rule 55 says P wins by default. D has 21 days from service, or 60 days if service is waived under Rule 4D. They can also answer. That is Rule 8. D responds to the substance, allegations, in the claim. She either denies, R8B2, anything not denied is deemed admitted, except damages amounts, which is Rule 8B6. General denials mean D denies everything in the complaint. That's not a good idea. Rule 8B3. The D can also agree, but raises affirmative defenses. Rule 8C. He can say, I don't know, lacks knowledge or info to form a belief. He can counterclaim, D sues P, Rule 13. D1 cross claims, which is D1 suing another defendant, R13. Counterclaim is where they sue the plaintiff. Remember, they put their arm on the counter and arm wrestle. And then affirmative defenses are raised or waived in the answer. And then the third option is they can do a motion to dismiss, Rule 12. A Rule 12b motion must have a hearing to be decided before trial. If motion is denied, D must answer in 14 days. All right, and this is just a little extra thing, like we had random things that I didn't see in any of the other tests, but Rule 1, purpose of federal rules. These rules should be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. Ooh. Rule 3, commencing an action. A civil action is commenced by filing a complaint with the court. Rule 7, definitions. A1 through 7, a pleading includes a complaint, answer in all their forms, and if the court orders, a reply to an answer. And then B, 1A through C, a motion is asking the court to move and must be made in writing unless during a hearing or trial, state with particularity the grounds for seeking the order and the state relief of the sought. Rule 84, forms. With the dawning of the internet and accessibility, providing illustrations for rules and forms is no longer necessary, and thus they have been taken out. Thank you, Rule 84. And guys, that's everything. So there's a bunch of charts. Go through Goodno's slides, especially her review one, because I actually went through all of her slides, and then she put out her review one, and I'm like, oh, look, I literally printed out most of those. Good luck.